Sorry.
Out of the list, in the list,
Okay. Item 51, Your Lordship engaged me as an amicus curiae. That matter, Your Lordship.
51 in the weekly list.
No, supplementary list.
Okay.
Today's supplementary. Can it be taken?
Today's
51.
list. Okay, we will take it up. Just wait for.
item 11.
My lord.
Yes.
Item 11,
Mm-hmm.
the master case has not come. So in that case, I had submitted the written note of submission. It has been also heard 2 occasions. So let this matter be come along with WPC number
Okay.
22951 of 2017.
Release this petition along with the WP number.
22951 of 2017.
Yeah, 17.
Any date? Any date you also not fix.
I don't know whether it will come to this court or assignment. Least before the assigned bench. On you tell me the date, convenient date.
2 weeks after any time.
To give a date after 2 weeks. Any date. I'll give a date.
Lordship, item 9, the petitioner wishes to withdraw the writ petition.
Okay. Take the in view of
Item 22.
one minute.
Item 22.
1 minute. 1 minute.
Yes.
In view of in the terms of the memo, stand this portion. Yes. Yes.
22.
22.
Yes. I will withdraw this.
Withdraw. Okay. Council.
Our actual.
You are Mr. Nikunjo.
Yes, madam.
Mr. Nikunjo Kumar Dev. Land Council for the petitioner seeks to.
My lord, item 17. And the
17,
17.
Yes.
My lord, in this case, we could not trace the file, so permitted to give the soft copy.
2018 writ petition. Does it survive?
Yes, my lord, survive.
I'll just wait for a minute. I'll just take it up. Yes.
19 minutes.
Huh.
This case, Mr. Manoj Kumar Pati is conducting this case. Now he is in panel Council of Union of India. So I only pray for 10 days. So I will intimate the council a petition.
Mr. Manoj Kumar Pati, Land Council for the petitioner has been empaneled as a government lawyer. Hence, the council, hence the Land Council appearing on his behalf, 6 Okay. Yes. I took 3 withdraw. Memo withdraw 3. Let us rush through the list. Yes.
Item 1. Item number 1, the sole appellant died on 22nd October 2023. I have received the death certificate from the IAS lab.
The sole appellant, what is his name? Prakash Behra was stated to have expired on 22/10/2023, and the death certificate has been placed on the court. In view of the process, yes.
Item 2.
What is this matter? Defect pointed out. No.
Defect. The fresh defect.
Extra.
First is two.
First time after 2012. This writ petition is pending since 2012, when the matter was called appeared, hence one prosecution dismissed. Yes.
Item 4.
Yes, government writ petition. You come, Pulwan.
That is the matter hearing the. I think so. Next week take the instruction whether that matter is survived. Because that order of the planet still has been challenged in constitutional proceeding. Narrated to the release the vehicle. My doubt that the vehicle is released. We can take instruction on this.
This is an writ petition filed by the authorized officer come ACL, Iwani, Forest Division, Pulwan. Then council for the submits that he would be seeking instruction regarding instruction as to whether the any cause is still surviving in the writ petition or not. In the event the cause of action doesn't survive in the writ petition, we move for appropriate application for withdrawing the same. And lease the matter next week before the roster bench. Date will be the Mr. Roast. Yes.
Item 5.
5.
I, the allegation that the two employees have received the old age pension. The page 12 is there that the purpose also that person had recovered that amount.
Recovered.
ଶରତ କୁମାର ପ୍ରଧାନ ସେତିକିରେ 1400 ଟଙ୍କା ସେ ବିଶ୍ୱ ସର୍ଦ୍ଦାରଙ୍କ ଠାରୁ page 12 ଅଛି।
Taking old age pension against the dead person. Harassing the villagers issues of
global मुझे मगाया।
I'll just simply dismiss for non-prosecution. The writ petition is pending since 2016. None has appeared when the matter is called up. It seems the petitioner is not interested to prosecute the case and it's dismissed for non-prosecution. Yes.
Item 6.
That he may be applied the Odisha government land settlement. And I say they are paying that the land may be settled in his name. Though there is a landlord person, he can apply on different.
On merit, I can't say anything. I'll simply dismiss for non-prosecution. Same. It seems the petition is not interested. Yes. Next.
Item 7.
Seven. Directing the chief executive officer of society and defines was not to allow was to work as the assistant secretary. For the
Society secretary appointment. Appointment of the society secretary. Earlier they filed the writ petition and the writ petition is disposed of.
This writ petition is pending since 2016. The petitioners have invoked the jurisdiction of this court inter alia, making the following prayer. When the matter was called for non-appeal, it seems when the cause of action doesn't survive, that's perhaps the reason the petitioners are not prosecuting the hence the phone is dismissed. Yes.
Item 8.
Infructuous and not less infructuous. The counsel for the petitioner submits that the matter has become infructuous, accordingly disposed of as infructuous. Yes.
Item 10.
Can file the suit. My lord, they are praying for the change his surname in the HSC certificate.
HSC certificate.
That cannot be. For their name.
Hearing the parties, issue appropriate direction or to correct the surname of the petitioner as well as the parent from Behra to
In
Senapati.
place of Behra, change the.
How can the writ court will do it?
Court cannot, that is the fact finding.
I don't know. The petitioners have filed the present petition inter alia, making the following prayer. The petition is pending since 2017. The prayer made in the writ petition, no writ could be issued to attend to the prayer made by the attend to the prayer made by the petitioners. Hence the petition starts disposed of non-prosecution as well as on merit. Yes.
Item 12.
Pending since 2012. 12. Yes. Leasehold land to freehold land,
That file is.
seeking a direction to opposite party number 2 to allow convert his leasehold land to freehold land.
That
E department.
municipal corporation, Bhubaneswar Municipal Corporation.
The appeal, the writ petition is pending since 2017. When the matter is called non-appeal for the petitioner, the APS petitioner is not interested to prosecution. The prosecute the present writ petition. Hence the list for non-prosecution. Yes.
Item 13.
Police coming from.
Well, 13 also,
Huh?
that challenge the OGLs, you can go to the OGLs that settle the land, that the landless person, the Odisha Government Land Settlement Act. OGLs Act, he can apply the OGLs Act.
Same code, dismiss code. Once dismissed in default, they will come and move application. If the cause of action really survives, otherwise they will forget. And once they move application for restoration, we will restore it. Therefore, it has to move first of all. Yeah. Yes.
Item 14.
Also
Same price.
Same.
Same. Settlement of claim. Same. Petitions for non-prosecution.
Item 15.
15, may I please, my lords, on behalf of Mr. M.M. Choi, my lords. That the petitioners are praying for the widening of the road. Widening of the road. From Khandara to Bisa Chowk, Bosua.
Movement of multi-axle truck on the road. Another issue. Something same is widen 4-lane road. This is how it can be issued in this.
Yes.
Widening a road, these are policy matter, the government will do it.
My lord, it's a-
Wherever the road is
it's a-
required to be
it's
widened.
a form of kind of PIL, my lords, let it be go to the
No, no.
range, my lords. Because my lord, 3,000 around trucks are moving on that road, my lord. The
The-
road is
That is,
still since, my
the
lord.
court will start deciding which road is to
My
be
lord,
widened.
there are
which road
various
to be
letters to
shortened.
the authorities to take up this,
No.
taken up this.
That
case,
is a
my
matter
lords.
of 2018. In the meantime, that might have been.
No, my lord, yesterday I have taken instruction, my lord.
Who are you?
My lords, the petition number 1 is at that time also the MLA, right now he is also the MLA of Bonai. And the others are the president of and secretary of United Mines Mazdoor Union and some of the
Was a
localites of the area.
complete frivolous petition. He was MLA, he could have impressed upon his party,
Yes,
the
he
government
has-
to do something he couldn't do,
He's-
come to the court
My lord,
for road widening.
he is not
And the
from
court will decide whether
from
road
the
has to
ruling
be
party.
widened or not.
He is not from the ruling party, my lord.
Whatever. Now he
Yes,
may
state-
be, now may,
Now also not, he is not from the ruling party, my lords.
I think you withdraw it. Instead of inviting a order. Withdraw to,
What you make prepare to next week?
no. Why?
Any day I will take instruction, I will
No,
withdraw it,
withdraw to agitate before the appropriate authority.
my lords.
Right, then council, the petitioners have filed the petition in the following prayer. Land council argued the matter, okay, some length, and thereafter, while responding to the query of the court regarding the maintainability of the writ, he submits that he would prefer to withdraw the writ petition to agitate the issue before the appropriate authority. With the aforementioned liberty, with this person. Yes. Yes.
Item 16.
Now, here the petitioner challenging the order of dismissal of the revision filed before the revisional authority, that the petitioner's land has been recorded in his father's name and that part of the land of the petitioner has been acquired by for Bhargavi barrage, and thereafter, after the acquisition, the rest part of the land has been recorded in their father's name, but rest part of the land has not been recorded. It has brought to the government land. Even if it remains with the petitioner, it is given. He has challenged before the authority, revisional authority, the said correction of ROR, but the revisional authority says that after acquisition, he could not.
I will get it listed before the roster bench, okay?
Yes.
Okay, Mr. Bahali. Before, and we will release the matter for the assigned bench next week, huh? Okay. Yes. Next.
17.
Yes. 17 is yours, Mr. Mishra.
My lord, I was checking up. I'm sorry, even the file is not traceable, but the cause of action survives because this is with regard to a swapping of a land. My lord, may I pray, my lord, I may be permitted to take the copy to swap more if your lordship permits and ask the lordship on the next day.
No, really cause of action survive?
Yes, because ମୁଁ କାଲି ଯୋଉ ଆସିଥିଲା ମୁଁ ଏଠି ପଢିକି ଟିକେ ଦେଖୁଥିଲି ଫାଇଲଟାକୁ ଅନଲାଇନରେ ଏଇଠି ଯେହେତୁ ପରମିଶନ ନଥିଲା କପିଟା ନେଇପାରିଲିନି କାଲି କୋର୍ଟ ଡିଡ୍ ନଟ୍
Mr.
ଫଙ୍କସନ୍.
Mishra, learned counsel, senior counsel appearing for the petitioner submits that the cause of action to maintain the writ petition still survives. However, he doesn't have the copy of the petition, hence he seeks leave of this court to take the soft copy of the writ petition and argue the matter once it is listed before the assigned bench.
No, may I pray, my lord?
Can you go to assigned bench?
Can you, for your lordship may not indicate assigned bench, only your lordship place it wherever.
Okay, he'll because obtain the soft copy of the writ petition, lease the matter on his request, lease the matter next week.
But 10 days
10 days.
instruction টা भी
My lord,
नहीं
the government has no copy, my lord, I may permit the copy. Copy or
Government ପାଇବେ ତାଙ୍କର ଯୋଉ କୋର୍ଟ ଥାଏ.
ସେଟା ଆସୁନି ଯେ ଯୋଉ
Oh,
Today one should not crave for copies. You carry your pen drives in your pocket and take it from here.
we have brought up.
Take it from here. Finish.
Right.
Now in digital world, you are
Exactly.
thinking for a copy, paper book and all. I don't think it's
Recently, an order was dictated. However, subsequently it was found the order is otherwise. The lawyer said that no, ये order dictate करते it नहीं. Then the court said, how come? Then the lawyer filed the
Video.
YouTube file. It's a contempt. How could you file YouTube? Sir, এটা ଆପଣ public domain ରେ ଦେଇଛନ୍ତି.
Yes, it's in
ମୁଁ
public
file
domain.
କରିଛି, sir, ଏଇଟା ଆପଣ ଏ order dictation
Yes,
କରିଛନ୍ତି,
of
ଆପଣ
course.
ପ୍ରମାଣ ଚାହିଲେ.
Of course.
I have given, and the order was then recalled and everything was sorted out.
So that is the transparency. That's the reason everything is there.
It's open.
It's open court hearing. That's the reason.
ଆଉ
You
ସେ
can't.
ଯୋଉ ଥିଲା ଫାଇଲ ଇନ୍ସପେକ୍ସନ ପାଇଁ ଗୋଟେ ଆମେ ଟଙ୍କେ କେତେ ପଇସା ଦବୁ, ସେ 15 ଦିନ ପରେ ଗୋଟେ ତାରିଖ ଫିକ୍ସ କରିବେ ଏଡିଆର ଙ୍କ ପାଖରେ.
Then you
ସେଠି
go
ଯାଇ
with a
file
pencil, keep on writing everything. All these
Those
things
things are gone.
gone.
ସେ rule should be amended also, ସେଟା ଆଉ ଦରକାର ନାହିଁ. ନାଇଁ.
Okay. Yes.
item 18.
Yes. 2020. What is he asking? Asking the award. This is an award. Seeking passing of the award. Good. I think it survives. The writ petition is pending since 2020. For the first time, the same is listed before the court today. When the matter was called off, none appeared for the petitioner. In the interest of justice, place the matter before the assigned bench. Justice. Yes. Next. Item 20. Let's see what is the prayer. The prayer is not required to see. Petitioner by directing the police to take up the restriction. The petitioner has invoked the jurisdiction of this court inter alia making the following prayer. When the matter is taken up, none has appeared for the petitioner. It seems the cause of action to file the writ petition doesn't survive. That's the reason the petitioner is not interested to prosecute the case, hence the matter is dismissed. Yes. 21. Yes. Government cut off rehabilitation and other classification for eviction for the present place of resident. Huh?
He says he is praying for CMC Kotak to rehabilitate the petitioner and other slum dweller in Malgodam area.
Oh, it's rehabilitation, right off. This writ petition is pending since 2021. For the first time, the same is listed today for hearing. None has appeared for the petitioner in the interest of justice. Least the matter for further hearing. And then least the matter for hearing before the assigned bench. Yes. Next. 23. Yes.
Here the because of the NGT has been challenged. Another at page annex of 14. Here another respondent, co-respondent had challenged the same order. And the collegiate bench has passed the order remitting the matter to the NGT.
Same order.
Same order. I am showing from that order.
The order, which is the order 14.
Annex of 14, page 299.
Right.
Annex of 14, page 299. You also say in the judgment, you also may see
18/4/2023.
That is the order.
What was the?
You also may see the original application number and the IA number has been mentioned in 3I. You also may see.
3I.
3I. Respondent 18. Here is the respondent 18. I am respondent 17 there. In original application 83 of 22 and the IA number 189 of 22.
83 of 22. Sorry, 22.
That was the order.
And IA number 189 of
22.
What is this? Considering the submission made by the senior counsel,
That order dated 18/4. Directing for criminal action.
Matter.
Here
The order.
respondent number 18 had challenged. Page 301 you also may see.
This what happened to after remission?
Remission that is pending there.
Pending there.
Pending there. Here only this.
Who
I am respondent 17 there. The petition in that case. Respondent 18. Agrawal in fact.
Okay, you are 17.
301.
You who are you?
I am 17.
17.
I am 17.
Sushant Kumar.
Sushant Kumar, Bharat.
You are Sushant Kumar?
Bharat.
Right. The writ petition.
Agrawal.
Okay. What is your name?
My name is Sushant Kumar Bharat.
Okay. The present writ petition has been filed by Mr. Sushant Kumar Bharat, assailing the order dated. What is this order dated?
18/4.
18/4/2023, passed by the National Green Tribunal Eastern Zone Bench, Calcutta, in original application number 83/2022 /EZ. IA number in IA number 189/2022 in original application number so and so. Okay, original application so and so. Let counsel appearing for the petitioner submits that the respondent number 18 before the NGT, Messrs. Agrawal Infra Builder Private Limited had also challenged the same impugn order in WPC number 26730 of 2023. The present petitioner has been arraigned as respondent number 70 before the NGT. The single judge of this court, by the order dated 8/1/2024, has set aside the impugn order dated 18/4/2023, passed by the NGT, and remitted the matter back to the tribunal for a fresh adjudication. He further submits that after remittance of the matter, the NGT seized up the matter and it's not yet decided. Not yet decided. Therefore, he submits that same order as has been passed by the learned single judge in writ petition number 26730 of 2023 may also be passed in the present writ petition. The submission made by learned counsel for the petitioner deserves merit in view of the order passed by the coordinate bench dated 8/1/2024 in writ petition 26730 of 2023. Accordingly, the impugn order dated so and so is set aside. Matter is remanded back to the National Green Tribunal, East Zone Bench at Calcutta to be heard along with to be heard.
I only be
heard.
given opportunity to
To be
participate.
heard by affording appropriate opportunity to the present
Giving opportunity to.
present petitioner as well. Huh? The order dated so and so, the photocopy of the order dated so and so is placed on record. Allowed. The writ petition allowed. Yes. 24. Yes. 24. What is the
Of the
correct?
poultry farm.
Huh? Passing the illegal
back
order
to-
dated
fall
so and
back
so,
to-
passed by the collector of so and so, and allow the petitioner to run his poultry farm. 23. The writ petition is pending since 2023. For the first time, if you will listed before this court, none appear for the petitioner. You are appearing 23? Okay. This is the matter before a signed bench. Yes.
25.
Yes.
I have already filed the document under need copy of Annexure 11.
What are you asking in the writ petition, sir?
Here, the common order passed by the Puri administration, Srijan Temple is under challenge.
Impugn order dated so Annexure 16. Annexure 16. Let us see Annexure 16. What is this? Communication.
We applied for settlement of land that has been rejected.
Ah.
And I want to file something. This is the legal bench order in connection with one of the case.
One of the case means
There is a common order and that is under challenge and the division bench issue notice and that is pending.
ending.
Miller.
How this has gone to division bench?
That
And this
might-
one, this is now listed before single judge.
I don't know, but since special.
Which common judgment, the same order. challenge.
Yes. Common judgment. Impugn order under Annexure 16.
16, huh?
Miller.
How will I know that common order?
Miller.
How will I know common order? Except the order, which case number?
Miller, there are so many cases.
Huh?
In that case,
How will I know that it's a common order?
but I'm-
Show me in this writ petition, What was challenged? Nothing is written here. Direction upon the authority to record the land, subject matter of land sale, case number 117 of 2014.
That
Yes,
order
yes,
was,
yes, yes.
that order.
Land sale, it is there, just see page 9, it's there.
Mm.
There. Madam, the petitioner is receiving the order dated,
My lord, I am appearing for the 4 and 5.
yes, I'm just, petitioner is receiving the order dated, order dated 23/5/2023 at an Excel. Sixteen, huh?
Millet.
In Excel 16. Who has passed this order? Hmm? Hmm?
Temple authority.
What is this document you filed?
That is a neat copy of Annex 11. That was the order of a settlement proceeding, and that was not legible. That's why I have a neat copy.
Okay. Okay. No, if you see, who has passed this order, you can see. Administrator, huh? Administrator SJTA Puri, dated 23/5/2023. Let the counsel for the petitioner has brought the attention of this court to an order dated 13/9/2023 passed by the division bench of this court in WPC number 25120 of 2023. He submits that this order impugned in the present petition was also was the subject matter before the division bench in the writ petition 25120 of 2023. The division bench 2023. In that matter, notice has already been issued to the opposite parties. Therefore, he prays that in this matter as well, notice should be issued. Mr. Ball has, Mr. You are appearing for? 4, 5, 6. Mr. Ball.
I am back to 4, 5.
4, 5, 6. So as to save time in issuance of process, I feel it appropriate to issue notice to respondent number 1, 2, and 3. Requisite to file within a week. Lease this writ petition along with the writ petition civil number 25120 of 2023 before the appropriate assigned bench. The order dated from so is taken. I will issue notice.
Yes, obliged. Requisite within 1 week.
Yeah. 26.
May I please, my lord? May I please, my lord?
Yes.
My lord, I may be permitted to withdraw, my lord.
Yes. Mr. Counsel for the petitioner seeks to withdraw the revision petition. Accordingly, the same stands withdraw. Yes.
Like,
Appearing his name is there. If do you have anybody who can give a memo?
my lord, I'll try, my lord.
Try and give a memo. Appearing in virtual mode. Submits to yes.
But I have also had an interim application first day of the
No, I will not say it. I'm only issuing because it is a matter of division bench.
No, sir. No, sir.
I am issuing notice only to save time.
No, only to serve and the notice also in IA. Only this much I am.
Doubt that. Yes.
One set of process.
Yes.
27.
Let it go to some other date, not prepared. It's a covered matter under the Northama Ratha case.
Okay.
And it was reaffirmed by the Honorable.
It's all right. Land counsel for the petitioner seeks an adjournment on the personal ground. Lease the matter up. Okay, next.
28.
28. 24 matter. Anything survive? Basically, please to issue direction to go to the party. This to the RC case number 19 of 2024. RC case. What is this RC case number? Okay, move that. See, 28. Is seeking expeditious disposal of the RC case number.
2013 के cause of action survive करना था.
Huh?
2013 case.
No, 2024 case. Just see. This is no 24. Item number
27.
28.
28.
Hmm.
28. Hard to 20.
He is seeking a direction for early disposal of RC case number 19 of 2024, which is pending before the Additional Commissioner Consolidation and Settlement Orissa. There is an application under 37(1). We'll dispose it up. The in this petition is the present petition is filed by the petitioner invoking the jurisdiction of this court to explore the following relief. It appears the following relief. The RC case number 19 of 2024 under section 37 bracket 1 of OCH and PLF Act 1972 has been pending before the Court of Additional Commission Consolidation and Settlement Orissa at Kendrapada since since February 2023. The petitioner is seeking direction from this court for early disposal of the said RC case. Speedy disposal of the case of present nature is right, which could be enforced through a writ petition. Since the prayer seems to be innocent, I am inclined to allow the writ petition with writ petition. It is expected that the Additional Commissioner so shall do well to see that the RC case number 19 of 2024 is finally decided as expeditiously possible. I will not give time bound as expeditiously possible. Item 29. Hard made and non-filing of annexes. All defects, 10 days time is granted to cure the defects. In the event the defects are not cured, the writ petition shall stands dismissed without reference to the court. Okay? Next. Consolidation. 30. Same order. Pending since 2013. Same order. Yeah. 31. Same. Infructuous. The counsel for the petitioner submits that the writ petition has become infructuous, accordingly disposed of. Infructuous. Yes, next. 32. Same. The writ petition is the revision petition is criminal revision petition is pending since 2014. The with certain defects which has not been cured, 10 days time is granted without reference to the court. It will be dismissed. Yes, next. 33. 2000 writ petition. Yes.
My lord, withdraw this matter.
Withdraw.
Oh, yes.
Let counsel for the petition moves and memo to withdraw the petition. Accordingly stands withdrawn. Yes. Next. 34. Defects pointed out by SR has not been cured. The writ petition is pending since 2016. 10 days time is granted to the petitioner to cure the defects. In the event defects are not cured within the stipulated time granted by this court, the writ petition shall be dismissed without reference to the court. Yes.
35.
35, 36, 37.
Hmm?
35, 36, 37. The defect one, two is timing.
Yes, 10 days time is granted to land counsel, but the petitioner submits that he would cure the defects within 10 days. 10 days. The writ petitions are pending since 2018. 2018. If within 10 days the defects are not cured, all the writ petitions stands dismissed without reference to the court. Okay. 35, 36,
37.
37. Cure it immediately. Cure it immediately to within 10 days. Here. 38.
38.
Same. Pending 2018. 10 days time is granted. If the defects are not cured within 10 days, the writ petition shall be dismissed without reference to the court. Hmm? Whatever. Yes.
39.
39. Same. Writ petition is pending since 2019. With certain defects pointed out by the SR. The same has not yet been cured. 10 days time is granted to cure the defects. If the event is not cured, same shall be dismissed without reference to the court. Next, 40.
40.
Writ petition is pending since 2020 with a certain defect pointed out by the SR, not yet cured. 10 days time granted. Without reference to the court, the same shall be dismissed. Yes. 41.
41.
But I am on behalf of Mr. Sukant Kumar Dalai. May this matter come after 2 weeks. Within this period, we will remove all these defects.
The writ petition is pending, so land counsel appearing on behalf of SK Dalai seeks 1 week time to cure the defects. Prayer is allowed. 10 days time is granted to cure the defects pointed out by the SR. In the event the defects are not cured within that time, the writ petition stands dismissed without reference to the court. Yes, next.
42.
Writ petition is pending since 2020. SR has pointed out certain defects which has not yet been cured. 10 days time is granted to the petitioner to cure the defects. In the event defects are not cured within 10 days, the writ petition stands dismissed without reference to the court. Yes.
43.
Same. Criminal revision is pending since 2021 with certain defects pointed out by the SR, which has not yet been removed. 10 days time is granted to the counsel for the petitioner to cure the defects. In the event it is defects are not cured within 10 days, the revision petition shall be dismissed without reference to the court. Yes.
44.
Same. The writ petition is pending 2021 with certain defects pointed out by the SR, which has not been cured. 10 days time granted. If not cured, will be dismissed without reference to the court. Same.
45.
45 also same. Order 21. Writ petition is pending since 2021. SR pointed out certain defects. Yes.
46.
Same. 21. Writ petition is pending since 21. 47 also.
47.
48. Writ petition is pending. 47 same. 21 is pending. SR pointed out.
48.
48 writ petition is pending since 2022 with certain defects pointed out by the SR, which has not been cured. 10 days time is granted. Yes.
49.
49. Same. The writ petition is pending since 2023 with certain defects pointed out by the SR, which has not been removed. 10 days time granted.
50.
50 same. 23. Read petition pending and all. Yes. Sure, no, nothing. No. Yes.
51 out of 50.
Hmm?
That's what out of 50. 51. Supplementary.
Yes. Supplementary over.
Item 8 was there.
Nah,
Day before yesterday, I directed me.
one minute. Yeah. Item 8, na?
Okay.
What do you say?
In spite of all best effort, now there is no chance of settlement because in the meantime, divorce is also allowed by the court. And when my lord knows a divorce has come up in favor of the husband, definitely
They will be adamant,
Yeah.
obviously.
And that not only that, from the very beginning, we can have a glance to the order sheet. My lord will found my lord's direction at least to pay 2 lakhs for the
Now, what is the alimony directed? There?
10 lakhs.
10 lakhs.
10 lakhs, and I have, my council has not exhibited any document.
And against that,
See, the problem with both of you is you are trying to spoil your own case.
yes, obviously.
You have trusted such a senior counsel. You will say something unnecessary.
And
get the
against,
case spoiled. Please.
And against that particular order of the judge family court wherein divorce of 10 lakhs has been allowed, one matter has been preferred, challenging that particular amount. And which the husband has also filed a application, matter, same way, that the amount of 10 lakhs is also very less. So now both the matter has been admitted and now pending procedural court for further adjudication. So now the fact remains, my lord, when on the circumstance when the parties are not in a position to settle, although it is our effort, on the one hand we are saying we are ready, but things have not been materialized because he has now a divorce has been filed. It has further aggravated the situation. That though there is absolutely no chance of any settlement, my lord. So my humble submission, 2 things, my lord, may take note of. First, against the order of the either to my lord interim order or final order, interim order, the remedy is the appeal to the criminal, my lord, because it's discharge. And against the particular remedy, against the order, any order of the particular discharge, criminal division is the best, the forum where the
I'm not going into maintainability. Just tell me what could be done.
My lord, in such a case, my lord, my humble submission, since the application,
Now the problem is, now since the divorce is granted, it is pending, and only the arrear could be recovered. Arrear prior to the divorce petition. Prior to the divorce.
No, my humble submission, since the DB application is pending, DB application is pending, and even if that will because that is the DB application has not reached its finality, only against the interim order, both the parties are fighting. So under such circumstances, my lord may, subject to acceptance, my lord, dispose of both the application, directly the court below to proceed in accordance with law.
This one. I can
And so far the amount part is concerned, whatever the amount part is concerned, if the honorable court is directed to pay 2 lakhs, now subject matter of this honorable court, whether my lord accept it. If my lord wants to comply the order, the directly that particular person, opposite party to pay, because the very purpose of each any honorable court is the paramount concern is the welfare of the child.
That is very
important. So if that is so, because
people can keep on fighting.
Let them, my lord. There will be no end to it.
No end to it.
No end to it.
Child, we are worried about the child.
And that's why, my lord, although that thing has not been taken care of by the magistrate, but while dealing with the application of the appeal, the Learned Sessions has specifically emphasized that let there be the husband will pay the schooling and other expenses. So that's why my lord is also kind enough to direct the husband to pay lump sum of 2 lakhs, which will be placed for the purpose of the fees of the child, my lord. So that's why my lord, I pray my lord subject acceptance. Both the case be disposed of directly.
Where is both case? Only one case is there.
Revision notice. Tired of revision TV.
No.
I'm sorry. Only CLMC 1204/2024. Directing the Learned Court below to dispose of in accordance with law. That will meet the purpose and subject which my lord wants because of to comply my lord's direction.
Because it is his petition.
His petition. And
what is he asking in this petition?
He has challenged the order of that appellate authority. That may turn to prayer.
For alteration, modification of ex parte order also on the filed by deputy parties to interim maintenance. And after hearing from both the parties, the impugn order is also. Annexure 3.
Right. Annexure 3 order of the appellate court. Next 3 copy of the order 25 4
What was the order here?
এইটা next 3 টা
Okay.
25 পেজটা
The premises taking into
40
consideration the offer submission.
page is 40 to 47 এইটা জানি 13/2/2024
These are the interim directions.
Madam,
Against
interim
interim
application.
direct-
Interim application is the appeal was preferred against that this he has opposition in court. And the main case is still pending.
Main case is still pending.
DB Act is pending for adjudication.
Okay. This criminal miscellaneous petition is directed against the interim order
Yeah.
dated passed by learned CGM Bhubaneswar dated 4/5/2022 under section 25 of DV Act and which has been affirmed by the appellate affirmed by learned sessions as Khurda in criminal appeal number 31 of 2022. By the impugn order, the petitioner has been directed to, what was the direction?
But initially he was directed to pay 10,000 rupees by the concerned court of SDM, which was subsequently affirmed and simultaneously accommodation was there. So instead of accommodation, 20,000 more was.
By the impugn order, the appellate court inter alia has directed agent para 7 of
Court.
annexure 3.
I get better.
Para 7 of annexure. Okay. Mr. Chand and counsel appearing for the respondent, private respondent submits that in the meantime, the application moved. In the meantime, the civil proceeding initiated by the present petitioner for dissolution of marriage has also been allowed with the direction to pay 10 lakh rupees.
10 lakh alimony.
As permanent value. The cross by the order dated.
But the judgment dated.
By judgment dated. Babies.
Judgment dated कहीं है? Divorce judgment. Divorce judgment. Divorce. Matter number 240. I'm just giving matter.
Particularly
Matter number 240/2025 has been preferred by.
The cross appeals have been filed by both the parties.
240 of 2025, 269 of 2025. 240 has been filed by the husband, 269 by the wife.
Which are pending consideration.
Admitted and pending.
The division bench of this court. In view of the subsequent development, this court feels it appropriate to dispose of the present petition with the liberty to the petitioner to resort to appropriate remedy under law. Moreover, the DV case number, what is that DV case? DV
227 of 2000.
DV case initiated by the respondent and the minor daughter, being CMC bracket DV number 227 of 2022. Is still pending before the court of SDJM
Bhubaneswar.
Disposed. Yes. No, pura the entire petition disposed. Yes. I'm disposing it.
My lord, may I add one line? 5/5/2025 judgment. And my lord, may I add one line because still the order of the honorable court has not been complied. He has not paid the amount. My lord, may also give the liberty to the opposite party.
Yes. Liberty is also granted to the opposite party
to file for execution of the either amount.
To initiate the appropriate proceeding for the execution of the order which stands in her favor. In her favor in regard to the her maintenance and the maintenance of the minor daughter. And in the DB, there is no direction for deposit of anything.
DB
No, sorry, a matter.
Matter কিছু হয়নি।
When it was admitted?
It was admitted. It was about February 2025. Both the matter has been admitted and notice has been issued.
Why don't you move application for direction for deposit of some money?
There will.
He is not paying actually, he is.
Well, that's paying or not, some you can.
My lord,
very well-
I'll take care.
Because I'm in that, this thing, I generally we pass,
My lord.
it is kind of money decree.
Obviously, my lord, obviously.
At least 5 to 7 lakh, he should deposit immediately.
And the very purpose is the child, and because of this type of adamant attitude of the husband, the school going girl was deprived to have this
Yes,
go to school for about 1.5
that's the
years.
worry, that's the worry. You can move appropriate application there and mention it. Okay. Okay. And he is come now. It's all right, it's all right. Go.
Supplementary list, item 51.
But here in this case, appellant number 1 died and it appeal abated.
Appellant number 1 died.
Died.
Let's see.
And so far as the appellant
It
number
has
2
already
is
been
concerned.
abated?
Madam?
Already abated?
Yes, yes,
Already
already abated against appellant number 1.
Okay,
Who
abated.
is residing and
10/10/2025. Abated. 10/10/25. Yes. Only Sanjay Patel is there.
Yes.
Yes.
He has been convicted to undergo RI for 6 months. And so far as the case of the prosecution is concerned, this appellant, my lord, is to charge for the offences under section 341, 332, 426, 379, read with section 34 of IPC and 31X of the SCN STPA Act. My lord, the trial took place in the special court, my lord, that is the special court Sambalpur, Judge Special Court Sambalpur. My lord, in the trial court judgment will show, my lord, he has been acquitted so far as section 341, 426 and 379 of IPC as well as section 3 of the SC and STPA Act. So far as the conviction is concerned, it is the finding of the learned trial court that this petitioner has been convicted only for the offences committed under section 332 of IPC, read with 34 of the IPC.
Para 9.
Para 9. My lord, what has happened, my lord? He has, while acquitting the present appellant from the charges of this other offences 341, 32, and other offences, he has said that the materials available so far as the evidences are concerned. So 3 vital witnesses, PW1, 2, 3, they have been turned hostile.
PW1.
One.
Who is the informant?
Informant is the one of the, he is the plaintiff and petitioner in the injunction petition. What has happened, the prosecution case is that, my lord, after the injunction order was passed by the learned court below, that was supposed to be served on the opposite party. Accordingly, he went to serve the order. By that time, these appellants, present 2 appellants, 1 died. They were present there and were sitting on the reach of the that land, my lord. Then when the processor went to that land, they caught hold of him and gave a slap from the backside of the head of my lord. Thereafter, appellant number 1 came and caught hold of his right hand. Appellant number 2 caught hold of his left hand. Both dragged the that processor to nearby house where he was confined. And this is the case, my lord.
Okay.
Lord, what has happened, your lordship may kindly see page 34 of the paper book.
Yes.
That is the deposition of the
One.
PW1.
Oh,
The
that is-
lordship will find in the second paragraph
There was a
declared
dispute between
hostile.
Govindo
possi-
and his son, Dhruva Patel.
Yes, Durga Patel.
Govindo and Dhruva Patel. Who is
Govinda and Durga Patel. The
who are they?
PW6 is the person who has my lord argued the matter and obtained the order of injunction.
PW?
6.
What is his name?
His name is
PW6 is, I know the accused person.
one Govinda. Uh,
Govinda
Pon-
Ram kya something, huh?
yes.
He is the-
He accompanied
he is
also the
plaintiff.
processor.
He is the plaintiff.
He is the plaintiff.
Okay.
He is the plaintiff. And the London trial court disbelieved the evidence, my lord, so far as other sections are concerned.
Plaintiff who obtained the injunction.
Yes.
Who obtained the injunction.
The relation between the
ठीक है.
PW6 and the present appellants
Let
are
us see the PW6
Yes.
first, then
Yes.
we will proceed
Yes.
further. I know both the accused
page
persons.
46, my lord, of the paper.
He is accused Dhruva Datta
Devadatta.
is my son.
Yes, the son of first wife. He has two wives.
Sanjay is my grandson.
Yes,
But it's son of first wife.
first wife. He says the Govinda had married to twice.
Right.
The first wife, my lord, from first wife. This
I got a land in Moza so under Khata number so. Occurrence took place in plot number so measuring so. The land was under my personal cultivation. Accused Dhruva served a notice to the construct of a pond. So I filed a case before sub-judge taking the injunction order was passed. The subject land against the so-and-so. On so-and-so, the court peon went to the post to serve notice of injunction. The village was meant Kumbo, Machi, so-and-so, so-and-so. Present. Where the injunction order. Both the accused persons had arrived at the spot prior to the arrival of the court peon in witness, and I also reached at the spot. I identified the land of the court peon. The accused Sibo Patel got hold of the head hair of the court peon, and other two accused Sanjay also got hold of
the hair of the
right hand of
the court peon.
They challenged him and assaulted him, and the accused persons took away the flag from the court peon, and the court peon was dragged by both the accused persons from the spot. And they left the spot, and after so and so. Who is the court peon?
Court peon is P44.
That's the P44. He is the informant.
My lord,
He is the informant.
P44 is the
informant.
court peon informant. Let us see what he says.
Page 41.
Yes. Informant. Yes. When the occurrence took place, I went to serve the injunction order of his case so and so, arising out of so and so, the court of civil so and so. On reaching the spot, I told the petitioner to identify the case, and at that time, accused Sanjay Patel was sitting on the ridge of the land. 10 to 15 persons were also accompanied us. At that time, Dhruva Datta came behind and gave a slap on my backside of the head after catching hold of my hair. And he also threatened me and saying, "You are the officer, cannot do anything." Accused Sanjay also came and got hold of my right hand, and other accused cut my left hand and giving me a kick on my back. And they dragged me in their house. They also told me the plaintiff has to also process about. Seeing this, the people who were combined fled away. They also forced me to write the document on a plain paper, review, so. Okay. And who all are the witnesses?
My lord,
One, two.
eyewitnesses 1, 2, and 3.
Declared hostile.
Eyewitness.
Eyewitness to the occurrence.
They didn't support.
They didn't suppose,
Aye.
they turned hostile. And the learned trial court, my lord, finding is that
Hmm.
because so far as the other offences are concerned, he has been acquitted. That from that evidence, he, my lord, derived some part of the evidence
Hmm.
from the hostile witness and utilize it for the conviction of the appellant so far as section 332 and 34 of IPC is concerned. There is no direct evidence, nothing is there. So far as the assault part is concerned, he has not
believed.
he has not been examined medically.
By the doctor also, huh?
No, though requisition was sent by the police, but he was not examined. And your lordship may kindly say, what a minute.
May not be, but IPC then. Hmm. What are the ingredient of 332?
Public servant, assault, including a public servant.
If the assault is gone, then can the other part survives?
But yes, the London trial court has disbelieved the evidence entirely, my lord.
Voluntarily causing harm
Deter public
to
servant.
deter public servant to, but
From his duty.
voluntarily causing harm to any person being the public servant. If the assault part is not believed,
Why it will not be believed, my lord? Section evidence of PW4 is there, corroborated by PW6.
no, the trial court has not believed
Trial-
it seems.
Trial for
Trial
para
court,
8.
my lord, that's why convicted under section 332.
But once acquitted, 323 acquitted. 323 was also there.
379.
341, 426, 379.
341 is wrongful confinement, that is.
That may not be there.
That has been disbelieved. What remains? Only the medical evidence. That has also not been done.
Then for assault part, PW4 and 6.
PW6.
6.
PW4 and 6 are there. And the other people, those who turned hostile,
My lord.
they have said that you were there. Presence
No.
is proved. Your presence at the spot is proved. Through even their hostile witness. Just see, come to 2. On 21 so and so, the occurrence took place at about so and so. Gramaraki called me saying that we should go to the case land with the court peon, and the court peon told me that he wanted to seize the case land and post flag, and on the request of accompanying the case land before he reached land, the accused Dhruva told not to go there, and thereafter he came and so and so. So Dhruva's presence and the court peon's presence is already there.
No, the deposition of PW1 Millard, that he has been turned hostile, but before that he has been he was asked leading questions. Thereafter, that was Millard, the London trial court finding is at para 8 of the judgment. May I place Millard? Coming to the offense under section 341, 426 and 379 IPC, read with 34 of IPC, I find substantial force in the contention of Mr. Behra that the prosecution evidence is not convincing to record a finding that both the accused persons have committed an offense under section 341, 426 and 379 of IPC. The flags were snatched away from the hands of the Gramaraki as deposed by the process server. There is no evidence as to what mischief was caused by the accused persons. So I am of the opinion that the prosecution has not been able to establish its case beyond all reasonable doubt against the accused persons for the offense under section 341, 426 and 379 of IPC, and the accused persons are entitled for acquittal in this regard. And para 9. Coming to the offense under section 332, 34 IPC, it has been contended on behalf of the accused persons that the evidence of PW 1 and 6 should not be relied upon
when part of their evidence has been disbelieved, particularly when their evidence does not receive independent corroboration from the other independent witnesses, that is the PW 1, 2, and 3. On the other hand, it has been contended that on behalf of the prosecution that the evidence of PW 4, who is a public servant, should not be disbelieved because it does not receive independent corroboration when his evidence stands on challenge in the cross examination. I am not inclined to accept the
Next page 16, if you go,
my lord.
it said that his evidence finds corroboration from the evidence of PW 6 and who had filed the suit and got the injunction order and had been to the case land with the PW 4 to identify the land. It's there. That's what the logic. That's what the logic is. PW 4, who is admittedly a public servant,
My lord,
went there to the spot. This has been established through PW 1, 2, 3, even though they are hostile. And the obstruction created by you is being proved by PW 6. Then 332 is
so
made
far
up.
the public servant part is concerned, my lord, the lordship will find in the entire trial, my lord, not a single paper showing that he has been deputed or he has been directed.
He had gone to
Serve the injunction order, my lord.
public function.
In that, my lord, contest, while going there, my lord, he must have got all the documents with him. That should have been seized by the police, my lord, then and there. That has not been done.
I'll give you probation of offenders act. Huh? Give you. That's better way of doing it. Because 4 and 6 you can't doubt.
That non-examination of medically, that is also a vital part, because he has
hair and pushing and those things. Even if you send it to medical, what will you get? Nothing.
5 days he took for lodging the FIR. Delay is there, 5 days.
That's why you get the benefit of PO. Thank you very much.
I am obliged that I was conducting a case where my lord has.
You will have to handle a bigger responsibility.
I am very obliged for that.
Assist in some bigger matter.
I have brought that two decisions, my lord. Only one is your lordship's decision on the provision of Offenders Act. Your lordships have relied upon that Ramesh versus State of Rajasthan. That is the latest decision. Another decision is 307 case.
What was the case? Let me.
That 395 thila 395 38 converted ହେଇକି provision of appointers act ହେଇଯାଇଛି.
Okay. There are two appellants, surviving appellants. One is 74, one is 68.
Another 307, 5 years conviction. Entire this honor court has taken into consideration the age factor as well as that antecedent of that. Chinta Marandi case. Last night I verified only that Ramesh versus State of Rajasthan was the test case. You will also kindly come to para 9 in Chinta Marandi's case. Para 9, as regards to submission of religion
No, but
petition.
it was, what is the prescribed sentence in 395?
395.
Whoever commits dacoity
7 years.
shall be punishable with
Yes, 7 years
of life
imprisonment.
or
Yes, 7 years imprisonment has been.
rigorous imprisonment for a term which may extend to 10 years. Hmm? 7 years is given, but what is the prescribed sentence?
Prescribed sentence up to life.
Let's see,
Up to life for the 95.
Prescription. To move the little comments.
Up to life. Up to life, my lord.
It is 307.
No, 395. 307. 307. 307.
Chinta Morandi.
307.
Provision is granted.
That is punishment is life.
No, these two judgments will provision of offendership. This is provision of offendership.
There will be 307 up to life.
307.
Yeah.
Provision of offendership.
The offender shall be liable either to imprisonment for life or to such punishment as is herein before mentioned. 307. Other 395 up to life.
And if the hurt is caused to the person by such act, the offender or either
Para 9 ଟା ହଉଛି କେତେ ହେଲାଣି 80 years incident, 30 years back.
No, those things are not important. Para section 4 of provision of offenders activity, the act itself bars.
Bars for death or life imprisonment.
That is what I am saying.
In Chinta Marandi case, this honor court has taken into consideration those factors.
Power of the court to release certain offender provision for a good conduct. When any person is found guilty of having committed an
that is somebody has been imprisoned,
not punishable with death or imprisonment of life. And the court discretion can do.
That punishment ଯଦି ହେଇଥାନ୍ତା life ହେଇଥାନ୍ତା.
No. Punishable and
punishable.
Punishable means prescribed sentence.
Yes.
If the prescribed sentence is life or death, then section 4 doesn't apply. That is the law.
କିନ୍ତୁ Chinta Marandi case ରେ
Chinta Marandi case, just see, when was the case Chinta Marandi?
Chinta Marandi judgment is dated 14/7/2000.
Judgment incident I'm talking about.
Incident was 30 years back. 30 years back means 92. No, 92. এটা 88 বর্তমান আমার যে প্রেজেন্ট কেসটা।
I have also keyed in the forward, but 307, 307, right?
Punishable up to life.
And the circumstances that if he may have to cause death. Second part is life imprisonment. Just see 307.
Second part.
The hurt is caused to any person by such act, the offender shall be liable. See, the first part is 10 years. So therefore,
And punishable imprisonment of either decision for a term which may extend to 10 years and shall also be liable to fine. And if hurt is caused to any person by such act, the offender shall be liable either to imprisonment for life.
so second part is life, first part is
Up to 10 years.
10 years.
So therefore, but here direct life imprisonment 395. And you have not got anything in 395.
395. Only Panavata CJ identified it. Out it's in
Can you convert it to robbery?
Robbery ହେଲେ
Robbery shall be punishable.
7 ଜଣଙ୍କର ଡାଉଟଫୁଲ ହେଲା ଆଇଡେଣ୍ଟିଟି। 7 ଜଣଙ୍କ
କନଭିକ୍ଟ ହେଇଛନ୍ତି ନା, କନଭିକ୍ଟ
395 right.
କନଭିକ୍ଟ କେତେ ଜଣ ଅଛନ୍ତି? 8 ଜଣ ଅଛନ୍ତି ନା?
8 ଜଣ।
How will you bring them to robbery section?
In respect of only appellant number 4. Appellant number 1, your lordship has to opine that you will be acquitted. Your lordship opine that in respect of appellant 1, no seizure is there, therefore he will be acquitted. But in respect of appellant number 4.
2, that's find out to be. Chalo, let's see. What best could be done?
Or at best your lordship may do that sentence undergone.
What is the period undergone? That also you have not said.
That is I could not get my right.
See, from the record.
And your lordship also, record I have already checked up earlier.
17, no?
No, it's 9.
17. No, just see the final form and proceeding and all. What is the name of the appellate?
Appellate is Virendra. Virendra Jena.
Virendra Jena. Virendra Jena.
Previously, your lordship has also sought for instruction from the State Council, and that could not be ascertained.
Just check it up. See, charge sheet, just see. Virendra Jena.
Charge sheet.
Find out. Virendra Jena.
Virendra Jena.
Accused number. Virendra Jena.
Court record ହେଲେ ଜଣା ପଡିଯିବ।
Nine, মানে চার্জশিটের একুশ নম্বর 9, হ্যাঁ?
Only lower court order sheet available. Lower court order sheet arrest date ଅଛି 27/1/1988.
28/88 ରିମାଣ୍ଡ ହେଇଛି।
27/1/1988 28 TI parade ହେଲା 30/1
28/18
arrest ହେଲେ 27 ରେ arrest ହେଲେ
28 ରେ ରିମାଣ୍ଡ ହେଇଛି।
ରିମାଣ୍ଡ
ବେଲ୍ କେବେ ହେଲା?
ଦେଖୁଛି
ମୁଁ ବୋଲେ GMFC କୋର୍ଟଟା 395 ରେ କିନ୍ତୁ ରିଲିଜ କଲି। ବେଲ୍ ବଣ୍ଡଟା କେବେ ଦିଆହେଲା ମୁଁ ଦେଖୁଛି। Passengers belonging along with memo number so and so. ଦେଖିବା। Passengers values send the LCL. Accused persons are produced. Receive back the case record. Connection is number. Bill person is rejected. एक दिन
12 ना
12 ना
कौन है
एक दिन
दिन
होता है
सीरियल
सीरियल रिलीज ना তারপর তো কোন criminal investigation number session valuation তারপর তো পড়াই রেকর্ড ঠিক না Bail bonds filed.
Okay.
As the bail bonds filed,
खासी कौन अच्छी है उनका डेट
sessions is valid, sir. This case is allowed the accused persons. चार जन रिलीज के
ना कौन है सीताराम जन
सीताराम
सीताराम
ବରେନ୍ଦ୍ର ଜେନା ପରେ ରିଲିଜ ହେଇଛି କେବେ ଡେଟଟା ତ ଦେଖାଯାଉ
खासी कौन लिखा है इसी आप पूरा देखना
30/4/88
এটা कौन सी 4
बेल बॉन्ड केବେ सबमिट ହେଇଛି 6/5/88 6/5/88 bail bonds were submitted.
Arrested on
27/1/80
नहीं होती है
80
88
arrested, huh?
आगे
Bail
6588
अच्छा তাহলে কনভিকশন হয়েছে কি 7 বছর
7 ବର୍ଷ
কনভিকশন করে
and impugn order was when they got bail
3 months, 9 days
during trial.
during trial.
Yeah, how 3 months?
3 months, 9 days during trials.
January, February, March, April, May. ठीक है 3 months 19 days
9 days
9 days. And after conviction
7 years
When you got
After
bail?
conviction.
केवल sanction from the judgment date तो देख ले
Conviction नहीं था।
judgment date तो देख ले
3,792 bail granted. 3,792. Judgment is 3,592. 3,592 judgment.
35 bail.
So ATB about 1 month.
1 month, 3 days.
1 month, 3
3
days.
days.
10/7/92 ଦେଇଛନ୍ତି bill bond.
In total.
So about 4 months, 10 days total.
12 days, sir.
Undergone.
ତାପରେ ଜଣେ ଖାଲି ଅଛି
2 ଜଣ ଅଛନ୍ତି 2 ଜଣ ଗୋଟେ ତାକୁ take into account that age factor, antecedent and length of the incident, period of.
Reduce the sentence. I'll have to reduce the sentence.
On that factor, your lordship can consider. Your lordship has the ample power to
Reduce the sentence substantially because see, the incident happened somewhere in 1988. And today is
38 years.
30 years back.
38 years back.
And he has undergone about 4 months, 12 days.
12 days.
Without remission.
No criminal antecedent.
Remission, everything is counted. It will be another 1 month or 6 months. Yes, Mr. Panigiri.
My age is 60.
67 years. 67.
What should be the sentence according to you?
My lord.
What should be the sentence? Because PO can't be given life imprisonment, section 4 bars. PO can't be given.
Your lordship direct for undergoing. The sentence is undergone.
Sentence undergone is only 4 months. 395.
Taking into account this aspect only.
Make it 1 year.
1 year will be too much violent.
1 year, then with remission and all, more than 6 months. Will come another 2-3 months he has to go.
The age factor and length of the year, lordship.
And fine is also there. Fine. 395. Fine. And fine or fine?
And fine. 95 or fine.
And shall also be paid.
And also,
so the sentence part, 4 months, 12 days, whatever has undergone. The sentence I'll say undergone and impose fine.
Also enhance the fine.
Enhance the fine up to, you tell me how much.
Let's
Either you have to go to jail or pay the money. About 50,000.
They pay gariba local. Gariba local. Pura
then the gariba local jagi raho ke din bhitre. Can't 395 conviction. How can
the other in the other.
No.
Actually, your lordship do it 5,000.
No. Then
your lordship 50,000. You can't pay, my lord. You can't pay. The condition I know, my lord. I have seen that condition, my lord. Therefore, I do not also, my lord, demand any breach of that. I have seen that conditions of that.
They should feel the pinch of it.
5,000 is
That's the idea.
My lord, 5,000 will be enough for them, my lord. That will pinch them, my lord. 5,000 is enough for them.
No,
Enough for him, my lord. Very, very poor, my lord. old man, now is unable to walk, my lord. You can see. Hon'Ble.
लेके चलो इसको. Any other matter is there?